Anyways, today another simple seminar, Freedom of Expression and Trademark Law in Search for Legal Mechanisms for Striking a Balance. Definitely highly topical, and we have Dr. Łukasz, let me try to pronounce that, Żelechowski, is that roundabout right?
Thank you.
Yeah, from the University of Warsaw. And I saw from your bio, Łukasz, that we probably not only met at that trademark law roundtable in Amsterdam.
That was Amsterdam.
Yeah, but we probably also met when you were scholarship holder at the MPI in Munich, because in 2007 I was there as well, but maybe we both don't remember, at least.
Maybe we haven't had a chance to talk, but maybe from seeing.
In any case, and I also found it really interesting to read from your abstract that you're looking at the different dimensions within trademark law of this freedom of expression. So whether or not for reasons of public order or morality certain marks may not actually receive protection in the first place, or perhaps within the infringement analysis, or perhaps within exceptions or elsewhere we can address this. So I leave it to you to explain this all to us, and well, thank you.
Thank you very much. First of all, I would like to thank you for the invitation. It's really a great pleasure and a great challenge. I hope at least to some extent to face it. Well, the topic is the freedom of expression and trademark law with a focus of trying, if it's possible, to find some kind of structural solution to this problem arising out of quite voluminous case law right now at this point. And the source of tension is quite obvious. This is the expansion of trademark law, which results to conflicts with interests of other actors at play, let's say, other traders, customers. And this results in a quest for balance between trademark rights as property rights, as a fundamental right. I will be referring here to the European Convention of Human Rights and the EU Charter, against other fundamental rights. A short excerpt from the Google case is the opinion of Advocate General, stressing the need to take into account when applying trademark law the freedom of expression, freedom of commerce is very often invoked in that regard. So I'll be focusing on the freedom of expression, although the two, that is freedom of expression and freedom of commerce, they might actually overlap, especially when we come to the issue of commercial expression, freedom of commercial expression, which I will develop later, in particular in the case of infringement. Some general notions, IPRs and fundamental rights. We have been through a phase, have been, so still are, through a phase that can be described as constitutionalization of IPRs, which is an increasing reliance of adjudicating bodies on fundamental rights in IP matters in different areas. And we can also say, I will also develop that later, that probably trademark law is right now following in the footsteps of developments in copyright law. And another phase could be called the internalization of fundamental rights into IP law, which means an explicit reference. And in the area of trademark law, this comes not with the provisions of the reformed trademark law, but still something important, the recitals of the respective acts, recital 27 of the new directive and of the current EUTMR. The thing about the cited excerpt is that it is placed, those recitals, they deal primarily with the issue of limitations. But the way that the references to fundamental rights, and in particular freedom of expression, are framed, I think, allows assuming that the significance of this reference is much wider, that it imposes the need to take fundamental rights into account when applying any provision of trademark law, even though they are placed in the recitals dealing with limitations. Freedom of expression. Apart from guarantees of freedom of expression in national systems, on the international level relevant for us, this is the European Convention of Human Rights, where the freedom of expression applies to any message, including commercial expression. That's what I was mentioning a few minutes ago. That has been said in several cases, in particular the second one mentioned here, the Sekmadienis against Lithuania, a recent case decided early this year that I will be talking about in more detail later on. and also the trademark applications, the case Dor against Romania, which I will also shortly refer to later on. Limitations, of course, are possible. They are set up in Article 10, Section 2. There are 3 of them. Was the limitation prescribed by law? Did it pursue a legitimate aim? And was it necessary in a democratic society, which can be described as a proportionality test? Was there a pressing social need for the limitation? Article 11 of the EU Charter, which refers to freedom of expression and freedom of information. An important thing about the EU Charter is that it, as far as the freedoms contained in the EU Charter are concerned, it accepts the standards set by the European Convention of Human Rights as the minimal standards. Of course, the EU Charter allows a greater protection under EU law instruments. The EU as an institution is not a part, despite attempts of the European Convention on Human Rights, but in an indirect way, the EU bodies, here I mean the EUIPO, can refer to Article 10 of the European Convention of Human Rights because the EU Charter takes those standards as the minimal standards, take the European Convention of Human Rights as the minimal standards when applying the Charter. So this is the case. Before we move to details of public policy and morality refusal ground and later infringement, I would like to refer to 2 cases that concern the commercial expression. This is the case I was mentioning, the case decided early this year. It was not a trademark law case. It concerned advertising, but the conclusions of this case come very close to what is important for trademark law. These were the advertisements, the wording, which is in a very fancy font, maybe it's not quite legible. This is, of course, the translation that I took from the site of the Lithuanian Organization for Human Rights. Mother of God, what a dress. Jesus Mary, what a style. And Jesus, what a jeans. What happened here is that the respective Consumer Protection Office instituted administrative proceedings against the company which ran the campaign, imposed a fine, not a horrendous one, approximately 580 euros. But of course the case was appealed and lost in all instances, including the Supreme Administrative Court. And the case went to Strasbourg. So the issue at stake was whether this was an infringement of freedom of expression. I would say it's quite interesting to talk about this case in the UK because as far as I know, the trademark Jesus for clothing was refused here several years ago as a trademark that may offend religious beliefs. So what did the Court of Human Rights say? Was the limitation prescribed by law? Yes. And which is quite important for trademark law, the court said public morals as an element of a legal provision is fine because it is a broad concept that cannot be precisely defined, which I think means also that public policy as a refusal ground in trademark law could not be questioned on this ground that it is not a sufficient legal basis for an assessment. There is quite, however, maybe the second intent here, quite an unclear fragment in this reasoning, which maybe is a reflection of some disaccordances between the judges, because there is a doubt expressed that maybe such a wide understanding would be insufficient for saying that also protection of religious symbols is embraced by this notion. Looking at it from the perspective, why was this raised? Because after the case became prominent in Lithuania, a change of law was introduced to the advertising law, which added this extra provision, which said it is contrary to this act to use in advertising religious symbols. Looking at it from the perspective of trademark law, I don't think that this doubt would really come to existence because we have the public order, morality, refusal ground in trademark law. There is also in the directive an option for member states to introduce a separate refusal grounds because of offense of religious, patriotic and so on beliefs. Not all the states use this possibility. The EUTMR doesn't have a separate refusal ground. I think the UK Act, the section 33A, also only refers to public policy and morality, so Jesus was refused on this basis. But still, those religious cases, let's say, they go through the public policy and public order and morality, so I don't think that this doubt was really legitimate here. That's what I would think at least. Did it pursue a legitimate aim? Yes, the court said. Was it necessary in a democratic society? No. Why? Because the explanations provided by national bodies were insufficient and vague. They basically were confined to saying that the advertisement promoted a lifestyle which was incompatible with the principles of a religious person. Who is a religious person? It was basically just the perspective of the Catholic Church. The Conference of Bishops was consulted on this issue. And the court said, why is this lifestyle not proper for a religious person? That was not explained. And of course, the court reiterated the formula that freedom of expression also extends to ideas that offend, shock, or disturb, and a certain margin of this has to be accepted in a democratic society. This is another case, Dor against Romania, which concerned a trademark application, a crucifix device. This was not about public policy, but it was about deceptive marks. What happened here is that the trademark, this crucifix device, was filed for financial services. And it was refused. And when the case came to Strasbourg, the questions were, was the limitation prescribed by law, the refusal for deceptive marks? Yes, of course. Did it pursue a legitimate aim? Yes. And the most important point, was the refusal necessary in a democratic society? The court said yes, because there could be a deception that the institution using the trademark is somewhat related to trade and maybe is more trustworthy when rendering financial services. But this was once again not about public policy, morality ground, it was about deceptiveness. So now I will move to trademark law strictly, and the first aspect is the public policy and accepted principles of morality refusal ground. There are proper bases in the directive, in the EUTMR. The rationale is the protection of the orderly flow of commerce. Of course, there is a certain margin for a judicial appreciation here. And the last two intents, the guidelines of EU-IPO, they separate those two elements, and probably rightly, because they are separated in the legal text. Public policy, accepted principles of morality, and they say objective assessment for public policy, for example, using the names of terrorist organizations, using names that are prohibited by law, or interference with accepted principles of morality concerns subjective values, but these must be applied as objectively as possible. My impression is, from the analysis of the case law of the EU-IPO, that this is pure theory, that when it comes to assessing specific cases, the EU-IPO doesn't really distinguish this assessment, and it goes through one set of criteria that I will have in the next slide. The question is whether this is proper, but the second question is, does it have any practical effect? Because if it all overlaps, which is also stated sometimes in the case of Board of Appeal or the Court of Justice, especially in a more recent case that I will be talking about concerning the name of a German movie. If they overlap, maybe it is not such a real problem that not enough attention is being paid in case law to separate examination of those two refusal grounds. So the set developed is basically applied for both of those grounds. So I won't be discussing those cases here in details. I will be referring to some of them to illustrate certain problems. Well, first of all, marks as such should be assessed. Intrinsic qualities of the mark. Standard of a reasonable middle ground person is to be taking account, no extreme approach, no extreme views concerning the marks. Somebody very easily offended or somebody who just basically takes anything as acceptable. Trademarks raising the issue of taste do not per se raise the issue of public policy or morality, and this trademark right here was registered. The need to take into account the context in which the trademark is likely to be encountered, assuming the normal use, this particular trademark was partially rejected. It was not rejected for goods that can be purchased in sex shops, because the reasoning was that here the clientele is ready to be faced with those kinds of expressions, whereas for goods that could be encountered in normal stores, let's say, where people involuntarily face them, for those goods it was refused. The assessment of the targeted public is not always a decisive factor. It could be sufficient that the public who is not targeted may still encounter the trademark, and that can be a sufficient ground for refusal. Not only signs with a negative connotation, this is the room for those religious symbols that can be refused. So these don't have to be swear words or offensive terms. And appreciation of diversity of conceptions across the EU. This Soviet coat of arms was considered as, it was rejected because it was considered to be offending to people in the former communist states in Hungary, and it was enough to find a refusal ground in a part of the EU to refuse the unitary protection. So now we come to questions. The major question that bothers me is the application of the public or the morality refusal ground limited by the need to secure freedom of expression? More specifically, is there an autonomous test, the one that was on the previous slide? Autonomous test, stand-alone test in the trademark law that has its own rationale, that is separated from the standards that we have in the light of the European Convention of Human Rights in particular, as regards limits to freedom of expression. So, in the EU IPO guidelines, you can find the statement that the assessment of this refusal ground is not limited by Article 10 of the European Convention of Human Rights. And this can be also traced down in a number of decisions, even if they refer to Article 10. For example, if this, the topic makes it sometimes a bit difficult to cite the names of the marks. So if you allow, I will say like SY, for example. In the SY case, the Board of Appeal said that refusal is not a gross intrusion on the freedom of expression because the mark can still be used. Of course, if there are some kind of other norms, public law norms, criminal law norms that prohibit the use of the mark, they will be prohibited under those instruments, but it doesn't mean they have to be registered. So this is not an intrusion on the freedom of expression. More decisively, here in those cases here, cited here, downstairs with those unpleasant words, freedom of expression is not affected by refusal, since the refusal only means that the sign is not granted protection under the trademark law. So the same argumentation, but put more forcefully, I would say. On the other hand, however, we have some other decisions. This is a decision, the first one. Here you have the translation, and a more specific translation and a very long German word. It was a movie with this title, a movie about 15th century relations and about a lady who was rendering the services at that time to clergymen during the Council of Constance in the early 15th century. And this is not a word, this is why I have this long German expression, that's what the Board of Appeal said. This is not a word that is in normal use today. It definitely has a historic context. And the Board of Appeal said that the EUTMR is not a linguistic rule book for the suppression of swear words, referred clearly to Article 10 of the Convention, European Convention of Human Rights, and I can cite the very last paragraph, which I think might be one of the better bits from the case law of the Board of Appeal. The Board of Appeal referred to the wide variety of services and goods. The wandering lady may therefore wander on, and her wanderings may be mapped using scientific and serving instruments, regularly updated in loose-leaf collections, edited using optical character recognition, expatiated upon in chat rooms, and declared as a sporting activity, although the board naturally assumes that the claimed education services intended are those relating to charitable social work and not those relating to education in prostitution. So another case is the Brexit case, where there was a very wide reference to Article 10 and Article 11 of the Charter, a very nice explanation why the Board of Appeal can reach to Article 10, even though the EU is not formally bound by the European Convention of Human Rights. And this trademark was refused by the examiner. This might be surprising to us, but this trademark was refused as an EUTM by the examiner, and the Board of Appeal explained that the fact that those in the UK who were in favor of staying might be offended or disturbed is not a sufficient pressing social need to refuse the mark. I know there are UK registrations of Brexit that have not been challenged. This is a UK case, the French connection case, which is, I think, is very interesting because here the appointed person also clearly referred to Article 10 of the European Convention of Human Rights and said there was no pressing social need for refusing this particular trademark, and it was necessary to protect the freedom of expression. I think this case is also a nice, as well as the first one, a nice example of the fact that we are not talking about a niche phenomenon, about people having crazy ideas about some crazy trademarks that has no business relevance. This is just, to make funny case law. Because in the first case, we are talking about a very popular German movie. And in the third case, we are talking about a brand for clothing. So these are really business cases where traders make investments towards promoting an asset, and then they face a refusal based on the fact that those marks, which are business cases, are then considered as immoral. This is a case which is now under appeal. It also concerns a German movie, which is targeted at youth, and it is basically about the frustration of young people when they have to deal with schooling and teaching and ancient literature or old literature. Anyway, this trademark was refused, and this was confirmed by the General Court. And the excerpt in red, well, I find this quite perplexing, because here it is not about just balancing the interest at stake, but it is making about a very clear statement that there is no room for freedom of expression in the area of trademark law. It's only available in French and German, this is my translation, but this is basically what it says in this paragraph 29, which is, I think, is a very far-reaching statement. And what the applicant was raising here was the Wandering Lady case, which went through. It was registered, the Wandering Lady. And here the General Court said it's not comparable because apparently this earlier title, it described the content of the film, I understand, by referring to the main character of the film, whereas this trademark does not explain the content of the film, and this first one was less vulgar. Once again, here we are dealing with a movie that apparently was watched by millions, was a huge commercial success. I think there is an American version of that, which refers to, I don't have it here, instead of F, it's S, me, Shakespeare. So it develops, apparently, and this is a business case as well. Interesting thing, the issue of distinctiveness was raised here because the applicant claimed additionally that the trademark is distinctive, and the General Court said it's not necessary to go into that because the Board of Appeal did not deny distinctiveness. I will get to distinctiveness of swear words and those offensive marks later, because this is also an important issue. Then this is another case, very briefly here, also decided recently here, the trademark La Mafia was registered because it conveys a positive image of the organization that is bad. This was questioned by the Republic of Italy. The trademark was registered. That was an invalidation case after several years of this trademark being registered. And now, the inspiration comes from across the pond. I'm focusing here in my presentation mostly on EU law, but I will make, in this case, a trip. And this is the Matteltam case, where the Supreme Court considered the disparagement clause as unconstitutional in accordance with the First Amendment. It concerned the name of a band, and the slants is a degrading name for Asian people of Asian origin. And the applicants claimed that they wanted to regain the meaning of this word, to deprive it of its negative connotations. And the Supreme Court said that the disparagement clause, which would be a basis for refusing this trademark, is in accordance with the First Amendment. First of all, trademarks are private, not government speech. So the fact that the trademark is in the register, it doesn't mean that this is government speech that has to be decent. Second, it is viewpoint discrimination, and the majority of judges thought that in this case it doesn't matter if it's viewpoint discrimination, whether it's commercial speech or any other speech, purely commercial speech would be subject to so-called relaxed scrutiny. There would be more room for prohibiting the freedom of speech, as with political or social speech. But here it was about viewpoint discrimination. The concurring opinion was that with viewpoint discrimination, it's always the same. It always has to be the very heightened constitutional scrutiny. Anyway, this disparagement clause was considered as non-constitutional. And that leads to dilemmas for the EU law. First of all, the first one that I highlighted, is there an autonomous test in trademark law for the public policy morality exclusion ground? Orderly flow of commerce, decency of the register, the fact that there is some awkwardness in the fact that a governmental institution is granting by its authority protection to something that we deem unpleasant, indecent, shocking. Or, in the alternative, should the public order morality be dependent on other criteria, not autonomous criteria of trademark law, but those criteria that are relevant for assessing permissible limits to freedom of expression? How could that go? Well, the first question could be, is the very existence of the exclusion violating the freedom of expression, like the disparagement clause in the US? I think that's unlikely, especially in the light that such a conclusion could be reached in the EU, especially in the light of this Lithuanian case I was mentioning earlier, where the court said public order as an element of a provision that prohibits advertising is fine. It's very unlikely that this would be found as violating the proper legislation which imposes a limit on the freedom of expression. And I also agree. I also think that there would be no possibility to question such clauses on the ground that they do not pursue a legitimate aim. So the first two elements of the limits to freedom of expression are fulfilled in the case of this clause. So basically it all comes down, I think, to the third element, and this is the proportionality test. And this is whether the adjudicating bodies should rely in assessing where the limits to freedom of expression, when applying the refusal grounds, they should rely on the standards proper for the proportionality test under Article 10 of the European Convention of Human Rights. I'm quite perplexed by the argument that, well, there is no intrusion on the freedom of expression if you can still use the mark. If you can use the mark, there is no prohibition by penal law, by administrative law. You can use it commercially. Why shouldn't you be able to register it? If you make an investment in promoting the mark and nobody prohibits you to use it, you should be able to get your ownership in that mark. That, of course, opens up other issues like distinctiveness of the mark. Can we monopolize certain marks? But that's a separate thing, right? The very first question is it a sound explanation? I would even think maybe that this could be a basis for some kind of empirical research, that there might be a chilling effect on the freedom of expression. Because if I am a trader and I realize that I will not be able to get a registration for an offensive mark, which is an attractive advertising marketing tool, I might be refrained from using it because it doesn't make sense to make investment towards something that I will not be able to register and obtain property in, especially in those systems that do not recognize protection of unregistered marks as property. So what would be the possible results of such a ECHR-friendly approach? That would open up the issue of other refusal grounds. And this is the question: do we want monopolization of swear words or religious symbols? If we had a pure F word, let's say, regardless of the goods, I think we could have a problem. Should it be possible for one trader to monopolize such a word? But if we have this name of the German movie, which is now under appeal, I'm not convinced. I'm not even convinced that there would be no primary distinctiveness. If the film has been seen by millions, has been a huge commercial success, there has been a huge investment made towards it. It's a neologism, it's a play on words, there is a misspelling here, of course, right? This is where I think we might have doubts. I have doubts, at least. I'm really curious what's going to happen before the Court of Justice. But I think there is a room for a certain, not monopolization, but commercial, very, very, very smart commercial exploitation of swear words, putting them into a context, onto a larger phrase, that can be an asset and that should deserve protection. Very briefly, because this is looking at the freedom of expression from quite a different angle. Because right until this point, I was looking at freedom of expression from the perspective of a trader who wants to express his commercial activity in a way that might offend or shock some people. This is looking at the at the freedom of expression of other traders and maybe public at large. It is sometimes called in the literature as the expressive diversity. And this is a new lane for this refusal grounds. This comes from this case, Municipality of Oslo, which concerned an attempt by the Municipality of Oslo of registration of trademarks containing works of Gustav Vigeland, an artist, to which copyright had expired. It's a very well-known case. The European Copyright Society produced an opinion on that. And the EFTA court basically said that exceptionally, I'm stressing, this refusal ground can apply to such works of cultural heritage. They would normally be assessed under other refusal grounds, like the Mona Lisa case, here a German case, quite old one, where the picture of Mona Lisa was refused registration because of a lack of distinctiveness. They could be refused under functional grounds, but the trouble is that if we have lack of distinctiveness, that can be overcome by acquired distinctiveness. So there is no guarantee that those works will not be monopolized. If we have functional features, we need to refer to the goods which have been applied for. And if we have, at the end of the day, this refusal ground, that gives the broader possibility of eliminating the monopolization of works of cultural heritage. But I'm stressing only exceptionally. As the court said, it has to be assessed, evaluated, what the cultural significance of the work is, what it would mean for the society to monopolize this work. So this is that much for this first part, which is about the public policy, public order. And now the second part concerns the infringement issues, where here in particular I would like to look from a more structural point. Very briefly, there can be various expressions that we might qualify as something that deserves protection as freedom of expression. This can be purely commercial expression, like comparative advertising, keyword advertising. This can be artistic expression, satirical use, parody. This can be social polemical message, drawing attention to a social problem, and instances which I think are most interesting, the instances of mixed expression, where we have a commercial aspect, but also an artistic aspect or a social aspect. So the question I would like to pose is, how do we deal with those instances within the framework of trademark law from a structural point of view, and in particular the question how much has changed, has improved maybe under the reformed EU trademark law in that regard? Do we have more tools? Does the stage at which we are making the proper balance change at some points because of the reformed infrastructure? And very briefly, of course, just to make order for my further remarks, I will look at the general criteria used in the course of trade in relation to goods and services, types of infringement, and then finally, limitations, exceptions, defenses. How can they be employed? Let's start with the general criteria. French cases, well, let's think, can we use those general criteria, use in the course of trade and use in relation to goods and services, can we use them to eliminate certain instances from actionable trademark use? Very concise, very brief decisions of the French Cassation Court, which, however, allow drawing the conclusion that at this point, as you can see, those two Greenpeace campaigns, this one against company Esso, this one against Areva, which is the company using atomic power, those decisions allow us drawing a conclusion that this was non-commercial use. So those instances could be eliminated from the ambit of trademark law, and here the freedom of expression, social expression, that particular instance could prevail. So there was no need to move to other stages of trademark infringement. A more complex case is this one, a German case, which is, as you can see, the background is the color of Milka, the chocolate, a poetically phrased sentence with the translation right below. I don't know if this is visible, but Rainer Maria Milka, which is a clear allusion to Rilke. Anyway, this is a difficult instance because these were postcards that were distributed for money, as far as I believe. And so this was a mixed instance of commercial, non-commercial use, artistic use, satiric use. So looking at this from the perspective of the general criteria, could we say this was not used in the course of trade and not in relation to goods and services? The German Supreme Federal Court said no. Infringement was denied, but at a later stage that I will get to in a couple of minutes. But at this level, the general criteria were fulfilled, which shows us that in instances of mixed use, these general criteria, they are not really a barrier for eliminating those fragile, satiric, polemical instances. The trademark law is growing and growing and trying to monopolize more and more. So it would be very difficult, I think, to use this very first stage of general criteria to eliminate a lot of instances where we would feel there is a need for a balancing of interests on the premise of freedom of expression. This is a Polish case, maybe internationally lesser known, and this was not a trademark case at the end of the day, because this comes from the reading of all three instances, the judgments of all three instances, but apparently the claimant didn't raise trademark law. What was it about? Allegro is Polish eBay. Yes, auction online site. And Foundation Greenlight, Zielone Światło, they organized a protest campaign because Allegro was allowing trading in Nazi memorabilia on its site. So they distributed for free leaflets with those middle letters Allegro, as you can see, stylized as the SS lightnings. Allegro filed for violation of its personal rights. Under Polish law, entities can enjoy protection of personal rights in a similar way as natural persons. So the reputation, good name as a personal right. I believe they did not base their claim on trademark law because they felt that probably trademark law would be eliminated here from scratch. This looks to me like those French cases. So I think this could be an example of a situation where even today we would say general criteria can be applied to provide the proper balance with freedom of expression already at the very first stage of assessment. I wonder what would happen under Benelux law, because Benelux law is, I think, the only system in Europe that implements this provision in the directive which says that if the use is not made for distinguishing goods of services, I think it's Article 10.6 of the current directive, the member states can provide for such a wider use if it's harmful to reputation, distinctiveness, takes unfair advantage. So I was even talking to a Belgian judge at one point, talking about this case, and she was quite convinced that in Belgium it would be eligible for an infringement under this provision of the Benelux Intellectual Property Convention. This is purely just to have a very quick look. I will not go into those details. Now we are moving to the specific types of infringement. Double identity. Of course, these could be cases of freedom of expression. Freedom of expression is very often about using the exact mark. However, rarely probably on the same goods, although we can also think about it. I think it's more about commercial freedom of expression when you want to have comparative advertising, for example, or keyword advertising. So I think commercial freedom of expression, but purely. There isn't really much to do here with those other aspects like social, artistic, because that will normally involve use on different goods, even dissimilar goods. But still, as far as what happens here is, of course, this expansion of the protection beyond the origin function. In L'Oréal, those other functions were in an unclosed catalog enunciated that can be protection within the framework of double identity. These are, as I said, mostly comparative advertising keyword cases. I would just like to say one thing about this, because this is, I think, purely commercial aspect. Apparently, the fears connected with the function theory, which allows a wider protection in double identity cases than just the origin function of those accessory functions. The L'Oréal case law, Arsenal L'Oréal case law, it created a great fear, I think, that the trademark law will explode. What happened afterwards, I think, is that the Court of Justice is has told us when an interference is not present than when it is present. So the functions theory is there as a concept, but we are likely getting information that a particular function in a particular situation is not infringed. So I think that those fears connected with the function theory they did not find confirmation in the subsequent development of case law. That's what I would think, at least. Likelihood of confusion, this is, again, not a type of infringement when there is much room, maybe comparative advertising, like the O2 case, which is, again, freedom of expression. The O2 case, the UK case, the comparative advertising of mobile services. I wouldn't like to develop this too much because I'm very much interested and would like to talk about with you about those artistic, social, and mixed instances of use. So this is definitely the area for the extended protection of trademarks having a reputation. Where can we find some room for a balance here, despite the criteria, of course, which are not very high right now, the niche reputation for a trademark having a reputation, any goods? Well, as far as the specific types of interference are concerned, we have quite severe evidentiary requirements imposed in the case law of the Court of Justice as regards delusion, detriment to distinctive character. They are arguably applicable also to detriment to reputation. But taking of unfair advantage appears to be like a wonderful weapon. My impression from the case law, not only L'Oreal, but also the case law, for example, of the Board of Appeal and the General Court as regards the relative refusal ground, is that this type of interference is really applied very easily. And the cases I will show you in a moment that came before national courts, they relied basically on this type of interference. I think this is where we have a major difference between the EU system and the US system, where in the US system there is a huge line of cases, for example, instituted by Louis Vuitton of different parodies of Louis Vuitton bags, trademarks. And the trouble is that it's very difficult for Louis Vuitton to demonstrate either delusion by blaring or delusion by tarnishment, harm to reputation, because these are the requirements under Lanham Act. Here in the European system, we have this concept of the parasitic competition, where we protect against the pure taking of unfair advantage, which is a very selfish phenomenon. I think Martin Zemfleben calls it a selfish endeavor. And I think this is where the protection of trademarks is at its most selfish point, because it's just basically purely about protecting the investment. But this opens up a huge area of a tool for trademark holders to try to suppress the freedom of expression. Aid can come with without due cause, flexible, undefined formula, which allows to accommodate different instances of freedom of expression. So even if taking of unfair advantage is established, the defendant can still say there is the due cause for using this particular trademark. And I will move this first instance here, which is very much about freedom of expression. Let's move to the German case. As I said earlier, there was use in the course of trade in relation to goods and services, but the German Supreme Court said the freedom of expression, and specifically freedom of art, which is separately mentioned in the German constitution, should be protected here. It should prevail, because the artistic, the humorous, the satirical aspect is so strong here that it would be unreasonable to grant protection. What type of interference was established? Taking of unfair advantage. The third one. And now, maybe, if you know these cases, the solution will be simple, but let's think. This is an Austrian case. Styriagra. Do we have any allusions? So, the defendant in this case was a company from Styria, an Austrian land, that produced pumpkin seeds in a blue coating. Pumpkin seeds are supposed to have, in a nutshell, a similar function as the pills of Viagra, and was selling them under the name of Styriagra. And goods dissimilar, trademarks vaguely similar, but the question was if similar enough to establish a link. And the Austrian Supreme Court said, what did it say? Was there taking of unfair advantage? Yes. Was there due cause, because it was a humorous way? No. No, the Milka case was invoked in the judgment here as well, but the Austrian court said it's not similar because here there is no artistic aspect. Satirical maybe, but no art. This other aspect of the mixed instance of use is not strong enough to overcome the prevailing commercial aspect. So in this case, freedom of expression was basically commercial, I think. This is a relative refusal ground case. Goods are identical actually here that were filed for. Again, which type of interference was at stake? Taking of unfair advantage. This again demonstrates like this parasitic type of interference is a very strong weapon for trademark owners. Was there due cause to refuse to allow the trademark? No. I'm quite bothered by this case because I think there is a lot of humor in it, and I think that basically anybody who would be wearing a piece of sports clothing or any clothing with this is basically demonstrating like a total indifference to all this, sports culture, body culture. So it's absolutely humorous, but still the owner of the trademark was able to prevail, and the trademark was considered as not eligible for registration. So the freedom of expression could not win. This is a very recent case that is pending before the Benelux Court of Justice, not the European Court of Justice, with a request for a referral. It's about the champagne, Dom Perignon, and an artist. There were three conducts or ways he used the trademark Dom Perignon. The first one was pictures of ladies carrying a bottle of Dame Perignon. I don't know if you can see it here, but it says Dame Perignon. Not Dom, but Dame Perignon. But the first instance is not here. A lady carrying a bottle. The second instance is another painting by this artist, but purely with the bottle, and there are several versions of it. If you want to see, you can try this site, but it is right now inaccessible. If you Google it, you will still see the thumbnails, but if you want to go and see them, you will see that the site is just not active. And the third instance were T-shirts with those depictions of the bottle. So what the commercial court in Brussels did was, said, the first instance, ladies with the bottle, that's pure art, this is not infringement. The third instance, use on T-shirts that were sold, this is use of a trademark, and this was considered an infringement under the extended protection taking of unfair advantage. In this case, there is a referral to the Benelux Court of Justice. Why not to the Court of Justice? Because it's, again, about this very specific implementation in the Benelux law. I think it's been there before, even before the harmonized EU law, which says that use for purposes other than distinguishing goods or services can be prohibited optionally by member states if it takes unfair advantage or is damaging to the distinctive character or the reputation. And of course the due cause defense is present there as well. I have to tell you, I'm bothered by this possibility in the directive, because for me, if the use is not made for distinguishing goods and services, I don't see a reason why even an optional possibility for member states should be in the directive. If there are rules in national unfair competition law or civil law or some administrative laws to combat those kind of activities, this is the national law system, right? But if it is not use made for distinguishing goods of services, it is from the very beginning not actionable trademark law. So I don't see, on one hand, a reason why trademark law harmonized should even bother with those instances. And secondly, if it does, why that should be in a trademark act. I would see room for that maybe in a separate directive, but this should not be really an issue for trademark law. But it is, and the question that went to the Benelux Court of Justice is, can due cause be invoked here in this particular instance? Because this is not use made for distinguishing those paintings, but those paintings are not that innocent, let's say, as those first one with the lady carrying a bottle, because the bottle here is in the first ground, right? So it reminds a little bit, Benelux is very, very fruitful when it comes to those cases, because there was the design case, the Nadia Plessner case, which concerned the use of Louis Vuitton bags with a boy from Sudan to draw attention to a social problem, and this was considered as freedom of expression, and the design right could not reach out to that. But this was a different case, because she was trying, this artist Nadia Plessner, to draw attention to a social problem. I don't really see much content here in anything else than drawing attention to the painting itself, not any other. So I'm curious what the Benelux Court of Justice will do in this particular case. And limitations and exceptions are. So what is important here for freedom of expression? Because this is just purely informative part about the new infrastructure. I think the referential use limitation, which has been extended, it's open-ended. The former indication of purpose, which was the only instance, is now an exemplary instance, expressly mentioned. So this open-ended referential use definitely, I think, accommodates room for artistic expression, social expression. Actually, I think, no, it's not in this presentation. In another presentation, I was showing how it went through the legislative process, and at one point the European Parliament wanted to list out more specifically those different aspects of referential use, including parody, artistic use. That did not happen, but it doesn't mean that it's not possible under the new referential use limitation. Maybe apart from the freedom of expression, I will just briefly mention a case which probably is very well known to you, but it's quite interesting. Sky against Sky Kick. There is a pending referral before the Court of Justice, but not concerning the issue which relates to fundamental rights. Namely, earlier in the proceedings, the issue at stake was if the new limitation of the own name defense only to natural persons is not violating several fundamental rights in the Charter, in particular the freedom to conduct business. And the defendant here was trying to induce the High Court to ask the questions, but the High Court said, before the decision on the merits, which can render the issue of trade name irrelevant, it doesn't make sense to ask this question. That opens up, I think, another lane for discussion, whether the new reference is proper, the new limitation, narrowed limitation is proper or not, but maybe this is not that very closely linked to the issue of freedom of expression, so I'm just mentioning it marginally here. Of course, we can discuss it about later in the discussion. The reference concerns quite different issues, the issue of the list of goods and services in bad faith. So, conclusions. Because I was trying to look for some kind of general infrastructure. First, the TMD and EUTMR have to some degree improved the legal framework which is suitable for providing the balance between the premark ownership, freedom of expression. Secondly, the point of gravity of the assessment might be located with different mechanisms. In particular, I think that probably there is more room right now for limitations and exceptions, in particular the referential use limitation, to take away much of the balancing that was done at earlier stages, general criteria, primary cause of action, to the level of limitations. I heard a couple of months ago Justice Jacobs saying that limitations, we never get to them. Because a lot of balancing is done at earlier stages, so maybe there is a room right now, at least with regard to referential use, to change that. For example, take the burden from the courts about thinking, is it actionable trademark use, is it used in the course of trade in relation to goods and services, by saying, yes it is, and by making the proper assessment later in the framework of the referential use, or the due cause defense with regard to trademarks that have a reputation. And a very important thing, those references to fundamental rights in the recitals, they are not a part of the provision, but they of course shed a light on the interpretation and application. I think they should play a very important role. And most importantly and practically, they should, and this is where the trademark law, I think, should and is already following in the footsteps of copyright law. They should render this traditional understanding that exceptions and limitations, that they are, exceptions to property, understood in a very classic way, and they therefore should be construed narrowly. This maybe works for tangibles, the property of tangibles, but with IP rights, there are so many tensions around the exploitation of IP rights that I think that we rather need to look at those limitations, what we call limitations and exceptions, as tools of providing a proper balance, as not as some kind of privilege that third parties are getting at the cost of the owner. So this I think will be the development, hopefully, in trademark law when it comes to the assessment of the applicability of limitations and exceptions. And I think this is what I wanted to present, and I hope we will have a discussion. I hope I was able to indicate some points that could be maybe discussed.
Okay, thanks a lot.